topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon, South Florida. Welcome to another Ask the Expert show, where we bring you the finest experts in the fields of legal, health, financial, and home improvement. I got to tell you, this is the first Thursday of the month. Without a doubt, my favorite show to do. And I don't just say that. This is, without doubt, if you are a board member or you live in a condo or an HOA, this is such a great show. People write us all the time how much they learn from this show. We get so many emails, so many phone calls, and it's just a great show. And what makes it such a great show is we are so lucky. Now, this is me saying this. My guests might not like me saying this, but this is the finest association law firm in the state of Florida. And I mean that with all my heart. This show goes by so fast, and we get your calls and we get your texts. Let me go and just introduce you to attorney Robert K. Bender Rimbaum.
Good afternoon, Steve, and hello, everybody.
Well, we're so glad you're feeling better. No more patch on my eye, at least during the day.
No more patches.
So, we get so many letters. I've got 80 shows around the country, and this show gets more mail than any other show. We welcome your phone calls. You can call us at 561-623-9429, or you can write your comments if you're watching us on TV right now, on W4CY.com TV, you can actually write your comments in. And you know what I'm going to do is I am going to, because we've had someone waiting for a while, Robert, I want to go to Rosemary. She wrote on here, what can you do when your condo association, which is more than 200 units, fails to post contracts and proposals?
Well, if you're referring to the requirement that the association post certain documents on the association website as required by the statute, the first step to do would be to notify the association in writing. Certified mail is one option. If you do certified, also send regular mail, because certified mail doesn't always reach its intended recipient. And you can send an email that would get there as well, and make the inquiry as to why those things are missing. If you're doing a formal inquiry under the statute, then that would have to be delivered by certified mail that trigger the statutory rights. If neither of those options result in the board doing what it's supposed to do, then you would need to notify the Division of Condominium in their enforcement section of the failure of the association to comply with the statutory requirement. In that instance, in all likelihood, they'll be contacted by a representative of the division who will likely resolve that problem. Hopefully it won't get a fine to the association, but it is a possibility that the division will impose a fine for the infraction. So that option is something you might want to hold off on. If you don't want to deal through enforcement, you still have the opportunity as a unit owner to bring legal action against the association for its failure to meet its statutory obligations. There are procedural requirements. If you're going to pursue legal action, it's best to consult with an attorney who's familiar with community association law in Florida to make sure that that gets done correctly.
Okay. Now, if you're watching on TV, we are scrolling right now all the classes that Kay Bender-Rimbaum will be conducting this month. If you're on radio, we will be announcing it during the show. But if you want to just look at the screen right below it, all the different classes that are coming up for the month of March, very busy month for you. You know, we've just gone to TV in the last several months, and we've got so many new listeners. Robert, tell people about your firm.
Well, Kay Bender-Rimbaum, as you say, is a community association law firm. It's 95+% of what we do is community association representation. All aspects of what an association may require and its daily legal needs, be it reviewing the covenants to determine whether there's a violation going on, whether the rights and responsibilities of the individual unit owners or of the association with respect to a given situation, pursuing covenant violations of the association against a violating owner, collection of unpaid assessments, providing opinions to the board as to any issue that they may be looking to deal with, whether it involves their governing documents or statutory limitations, dealing with cities and municipalities on issues that may be at issue with the association, contract negotiation, dealing with construction defects, developer claims, anything you can think of that involves association legal issues are things that we deal with on a daily basis. We have offices in Pompano Beach, Palm Beach Gardens, Orlando, and Tampa. And we have an office facility in Miami available on appointments for all types of consultations as needed by associations.
I just want to get this text in, and then we're going to go to the phones. They have a new association. This is in Boca, and they want to know, is your office open on Saturdays? And if they call, should they ask for any particular attorney?
The offices generally are not open on Saturday, and there would be no need to ask for any particular attorney. If you're looking to hire the firm as the association's counsel, you can reach us at 800-974-0680. You can write to us at info@kbrlegal.com, or you can go to our website, kbrlegal.com, and fill out a contact request form on the first page, and somebody from the firm will get back to you and explain how we can help.
Okay, we have lines open right now, which is unusual, but if you'd like to give us a call, if you have a question for attorney Robert Kay, the phone number here is 561-623-9429. Maybe you're part of a management company, you're a board member. If you live in a condo or HOA, feel free to give us a call here. Again, 561-623-9429. We're going to go to our first text of the day from Candy in Boynton Beach. Good, they're starting to listen to us, Robert. She said she lives in a condo. Who is responsible to repair a leaking pipe that is located between the floors of two units? The owner of the top unit or the association?
Well, that's going to depend on the provisions of the governing documents, the declaration of condominium for the particular building. In all likelihood, if the pipe is in the floor of one, the ceiling of another, it's likely in the common elements, but it may not be. That's the key, is to determine the specific location of where the leak is. It could be within a pipe that's only within the unit, but seems like it might be in a common element, but may not be. So that's an important consideration and identification of the specific source first. Generally speaking, the space underneath the floor of the top unit and above the ceiling of the bottom unit is likely going to be within the common elements, which would make it an association expense. But sometimes documents have unusual provisions, so you be sure to check the documents to see what's what with that. The association attorney may want to be involved to assist the board in establishing a procedure to deal with any kind of a complaint of that nature.
Okay, let's go to Roger in Pompano. He lives in a condo that just put pavers around the pool. The pool deck was just raw concrete. The property manager says that is not a material alteration. Is the manager wrong? What can be done about it?
Well, it sounds like this particular manager is one of the reasons why managers are not allowed to give legal advice by law, because that is completely wrong. Not only is the manager wrong on the law, the manager is now in violation of the licensing requirements of property managers in Florida by giving unlicensed law advice to the association. The manager should be consulting with the association attorney. Placing pavers on a surface that did not previously have pavers is a material alteration to the common elements. And under those circumstances, the governing declaration of condominium will have to be reviewed to see what standards there are for material alterations to the common element. The statute says they have to be done in accordance with what the documents say, whether there's an own or vote requirement, whether it's tied to a dollar value. There could be a number of different criteria to look at. If the documents are silent, the statute requires a 75% vote of the unit owners. That's supposed to take place before the alteration is undertaken. If it's after the alteration is undertaken, that could cause a problem for the association if anybody complains to the division.
Okay, let's go to Bob in Boynton. Can an owner not pay for an HOA amenity if they don't live in their home full time, or can they get a refund from the vendor like trash pickup? Even I know the answer to this one.
You are correct, Steve. The answer is no. You have to pay your share whether you use the amenities or not. That is one of the, sometimes people consider it the pluses, some people consider it the minuses of living within a community association. All of the costs of the association are split among all the members in accordance with how the documents are written. Sometimes it's equal, sometimes it's a percentage based on square footage. There's different situations that may apply. But because you don't use something is not an excuse for payment. There are no refunds. One good analogy is someone lives on the first floor of a condominium building, and why do I have to pay to have the elevators maintained? I never use them. Well, unfortunately, you have to pay your share for all of the common element repairs and maintenance costs.
That's a good analogy. What kind of feedback are you getting from board members about all the new statutes coming up in the next couple of years?
Well, there's a lot of anxiety out there, a lot of concern, confusion. I think one thing everybody's waiting to see what's going to happen. The legislature is coming into session in the next couple of days, and will be one of the items of interest will be how they address the statutory provisions that were put in place last year that are supposed to go into effect in the next year or two relative to all of the inspection requirements and the reserve requirements and what changes might be made to all of that. And there are some bills that are presented already. There are others that could be coming that haven't been made so public yet. But at this stage of the legislative process, it's likely everything that they're going to be considering on a serious basis has already been filed and starting to go through committees. So we're just going to have to see what shakes out. They're certainly concerned that these are going to raise the costs of operation and the costs of living in these communities. And in all likelihood, that's going to be true. But it seems like the hope is there's going to be a way to ease into it rather than jump with both feet, so that the financial hit isn't going to be as devastating to some as it might be. Now, a lot of places have been maintained correctly through the years and have always kept reserves. There are certain items within the statute from last year that weren't reserve items in the past, like foundation, which is a difficult issue to even put a value on. And foundation is usually something that doesn't really deteriorate. So that one's been an issue of concern to practitioners in the state all along. But, for those that have been taking care of their buildings appropriately, there's not going to be that much of a change.
Okay, let's go to our comment area. This is from Ace. He's always got really good comments. If you want to, and I like the way we put it on the board now in front of you. If you want to have a movie night on the lawn and invite owners and not charge for admission nor have any paid sponsorships, can an association do this legally?
Well, the one thing in that particular plan that could be problematic is that when you're showing a movie, that there's actually a license for that use. That is something the association is going to be required to pay. And many associations aren't aware of it, don't look into it, and do their movies, and then are later contacted by an attorney on behalf of whoever owns those rights to the movies. The showing of them, even in a private setting, can result in some exposure to a license fee obligation to certain individuals in the entertainment business. So other than that, there is no legal concern in what was described in that question.
I got to tell you that we have another comment I'm going to read, but Pablo Garfunkel, I think that's a cute name. Anyway, some members at a 96-unit condo, 718, want to convert to HOA 720. Motivation being paying all equal dollars versus percentage of internet driven by unit size. Is that even possible? And what does that entail?
Well, really, it depends on the construction of the condominium, whether it's possible to do. If it's multi-story type that you normally think of as a condominium, the ownership that people have in those is pretty much airspace within the units and the surfaces within the four perimeter walls, floors, and ceilings of the unit. The rest of the building is not owned by the individual unit owner. And certainly on the second floor and the third floor, there's no ground underneath that would be subject to a fee simple type ownership in real estate, which this is more of a complex real estate issue. But if you wanted to terminate your condominium, you have to look at the provisions of termination that are set forth in the declaration itself, and then look at the statute in Chapter 718. And then you have to create a new set of documents for a homeowner association if it's practical and physically possible. And then you need 100% of all the owners to sign off on it, to be bound by it, as well as the mortgagees that have mortgages against any of the individual units. It it does not sound like it's going to be practical resolution to whatever issue they're facing. The cost to do that would be in the tens of thousands of dollars just for documentation and legal.
Well, Robert, do owners, do they understand all their documents?
Generally, no, but that's okay. They're not easy to just pick up and read and assimilate for most people. You're supposed to have a working understanding of some of the more important provisions within them. There's a provision that says you have to pay assessments, and if you don't, what could happen? Lien and foreclosure. There's usually maintenance requirements that says what the association maintains, what the unit owner maintains. There's other use restrictions within there, what you can do, where you can go, when, how not to bother your neighbors, things of that nature. And there may be situations involving parking, limitations on where you can park or how many cars you can have, what types of vehicles you can have. Insurance requirements, usually that's an association responsibility, but sometimes there's also portions of units that are the unit owner's responsibility. Those are important things to know about. Those are the high points within there. There's other subtleties that every place is unique. They're not all the same. So it'd be a good idea to go through and get an overall understanding of what you're facing, because you do the wrong thing and you can find yourself at odds with the association, and that can run into an expensive proposition for the uninformed.
I got to tell you, I would want your firm there educating us on everything. And I guess they don't do that, do they?
A lot of them don't, but there's easy ways and hard ways, right?
I hear you. Okay, let's go to Ron in West Palm Beach. If we have no quorum, how does the board do business?
Well, the board cannot do business without a quorum in place, either physically present or on the phone or on a video, in a situation that other unit owners can also participate. If certain members of the board just refuse to participate and the association is never able to get a board meeting together to do the business of the association, then the association cannot function. The ways to get around that is either recall the individual directors who are not participating and put in individuals who will, address it at the annual meeting, or you may have to go to court and have a receiver appointed to take over the operation and management of the association, because you can't get a board of directors to do that. That is a very expensive proposition and the last resort that should be considered in all of this.
Well, we're going to go to break now. We're here with attorney Robert K. Bender Rimbaum, legal. We're going to give everybody the phone number again, Robert.
800-974-0680.
And that great website of yours.
kbrlegal.com.
We're going to go to break. When we come back, we've got more with attorney Robert.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. This is the Ask the Expert show. We're with you every Thursday from 5 to about 5:50. We're here with the K. Bender Rembaum law firm. They handle association law, and they do a lot of classes. And can we go over the classes for the month of March?
Let's do that. First up, coming is a week from today, Thursday, March the 9th, Navigating the Federal Fair Housing Act. That's a live presentation at 7:30 a.m. until 10 a.m. at the Fairfield Inn in Delray Beach. Peter Molengarden and Palm Beach Gardens office will be the instructor. It's hosted by ACE by TSK. Live presentation, 7:30 a.m. till 10 a.m. Next Thursday, Fairfield Inn, Delray Beach. And we have 2 board member certification courses in March. The HOA certification course is going to be Wednesday, March 15th from 5:30 to 7:30 p.m. That'll be hosted by Campbell Property Management and instructed by Danielle Brennan. The second is Wednesday, March 29th at 12 noon to 2 p.m. That's the Condominium Board Member Certification course. That will be instructed by Emily Gannon from Pompano office. On Tuesday, March 21, 12 noon to 2 p.m. on Zoom, dollars and cents. Jeff Rembaum will be participating in a discussion with the Castle Group, going over reserve requirements and situations involving financial concerns to associations. Then there's a joint community association board member certification class going to be given live in the Orlando office on Tuesday, March 28th from 12 noon to 3 p.m. With Alan Schwartzide of our Orlando office. There is very limited seating in the Orlando office, so it's important to make sure to reserve a seat. And then on March the 30th, we have Jumping into the Present, Why Updating Your Governing Documents is Critically Important, also on Zoom at 6 p.m. to 7 p.m., also hosted by Alan Schwartzide of the Orlando office. Before we see you again, there's going to be an expo in Broward County at the Signature Grand on April 4th. That's an all-day event, but we're teaching 2 courses there at 9 a.m. until 10 a.m., Covenant Enforceability of HOAs and Condominiums. And then at 2:30 p.m. until 4:30 p.m., there's going to be a Legal Update 2023, which is the legislative changes from 2022. I know Michael Bender will be doing the afternoon one. I'm not sure at this point who's going to be presenting the morning on the covenant enforceability, but it's going to be a good one for everybody who's at the expo to attend and see what's up with those issues. So that's March in a nutshell.
Busy month. Wow. We have somebody who wanted to do a follow-up about the movies. How is that different than having 20 friends over to watch a movie?
Well, having friends into your home is considered different by the individuals that address these licensing issues, because you're opening it up into the common areas as a community-wide event, and they want to get their piece of the action.
That makes sense. Hey, we have lines open right now if you'd like to call. If you've got a question for Robert, feel free to give us a call. The number here is, well, we just lost it. It's 561. Let me get it up here. It's 623 9429. That's 561 623 9429 if you've got a question for Attorney Robert Kay. Let's go back to we got so many text in over the last 4 weeks. Let's go to Ruth in Deerfield. She wants to know what basis would be considered negligent on the part of the condo management company, like lack of maintenance. How far does it go? When is the time to change?
Well, the time to change is a more esoteric question because you need more facts and circumstances to be able to pinpoint. But the first thing to look at is the contract that the association has with the management company, which generally lays out the duties and responsibilities of the management company to the association. Where we oftentimes see issues of problem is how timely are the accounting records prepared? Is the board able to do its financials on a timely basis, or are they coming in a month or two after they've occurred, which makes it a lot more difficult for the board to function? On-site maintenance and management is an issue that may be the manager's responsibility, but it's important to keep in mind that any management company, any manager is an agent of, or even in times an employee of the association, and is overseen by the board of directors. So it's really the board of directors that should be making sure that all of these items are being taken care of in a timely basis. The time to make a change also may depend on what your contract calls for. Some contracts are written to allow for termination anytime with 30 days notice, with or without cause. Sometimes there's 60 days notice. Sometimes there's a requirement of cause. Sometimes there's a 6-month waiting period before you can cancel it to give the new manager a chance to get established and get working in an appropriate fashion. So the facts and circumstances of the situation are going to have to be viewed fairly carefully to reach the ultimate determination of what the best course of action is and whether a change is something that would be a good idea or a bad idea.
You know, we got a lot of mail, and we continue to get a lot of mail about renters and who they can accept, who they can. Here's Stephen in Aventura. Do we have the right to deny a renter who does not meet our protocols, minimal credit score or debt to income ratio, even though our attorney is saying it's to our benefit that this applicant has additional income? Your thoughts?
Well, the standards for leases are not as stringent as they are for sales. And unless the documents provide for specific criteria, the association has the ability to disapprove leases, assuming the documents give them the right to disapprove, for almost any reason that is not one that is constitutionally protected: race, religion, creed, color, age, sexual orientation, things of that nature, that you would never use as a basis. But if somebody, like a tenant's income, the old school thinking on that was it doesn't really matter because they're not the unit owner. But when the legislation changed to allow the association to pursue the rent in the event the owner becomes delinquent, the income of the tenant has become a relevant consideration for the association in deciding whether an individual is going to be approved or not. So, income can be a factor. Other history of rentals in other places. If on the face of the application, the individual is indicated not to qualify under the documents say there's a restriction on trucks and they drive an F-150 for their only vehicle, right there on the face, they're going to be in violation of the documents. And so that would be a basis to disapprove also for a sale. So again, the specific issues that are presented have to be considered before you can ultimately decide on whether or not to approve or disapprove. But that's some of the overview on it.
Okay. We just got a text in. Somebody wanting to know, Robert, about mask. Does the board decide where masks must be worn, or can they even make that decision?
Well, mask wearing these days is not the hot topic that it was a couple of years ago.
Right.
A lot of places were having rules in place on the common elements requiring masks, but I think now that all of the states of emergencies have gone by the wayside, whether or not the board can compel mask wearing and the common elements is an open question. For the board to make a rule that's enforceable, it has to basically clear 3 hurdles. The first would be the documents give the board the authority to make such a rule. The second is that the rule doesn't conflict with anything in the recorded documents. And the third is that the rule has to be reasonable. And I think in this situation, that's the hardest hurdle for a mask requirement to cross, is whether or not it's reasonable under the circumstances. In some communities where you have some of the more at-risk, a large percentage of the more at-risk population, people over 75 years of age, that might be a situation that could be considered more reasonable to require it. But even then, it's more in a gray area, I would say.
Okay. Go to Christy in Coral Springs. Is the president allowed to fire a contractor without a vote by the board, not just the president of the board?
Generally speaking, no. The president doesn't typically have that level of authority without the board giving it to him or her in advance. The termination of a contract, the hiring of a contractor, those are functions of the board of directors, not the president in its role as the day-to-day operations officer. But certain situations may occur in which the president is in a position of having to take action, and hopefully the board will support that action. But as a standard procedure, my answer would be no.
Okay. Let's go to the phones. We have a call from Stan in Fort Lauderdale. Hi, Stan.
Hello, Stan. Are you there?
Stan? We might have lost him. Is he
I'm
still
here.
there? Oh, hi, Stan.
Yeah, I'm here. I'm there. Can you hear me?
Okay, you're there.
All right. My question is, if you live in a high rise and a person purchases a unit, subsequently gets not 1 but 2 dogs, whether it's a DO or a medical doctor that gives them the provisions, and they document specifically prohibit dogs, is there a limit to the number of animals that a person can have?
If you're talking about an emotional support animal or a service animal in the housing setting, the laws are geared to bend toward the requesting unit owner and not to the association and the rest of the unit owners within the condominium. If the medical provider identifies more than 1 dog as needed for whatever issue is being identified that would qualify under the fair housing laws, then multiple dogs would have to be allowed. But it all depends on the way the medical provider writes their letter of the need and how they express it. It can't be that this person needs 5 dogs in order to get through their day. They have to identify the specific dog and how that dog alleviates whatever issue of major life function that the individual needs assistance with.
Does that answer your question,
Thank you.
Stan?
Yeah, it does answer the question. It's just suddenly the person moved in and they seem like a normal, reasonable person, and then suddenly they want a dog for whatever reason. Now suddenly they have issues, but before, when they went the vetting process, they don't have it. So I was just curious, but who am I to say that they don't have issues? And then they come in with 2 dogs, documents say no dogs, and then it just creates a hornet's nest.
Well, there are ways to challenge it, but it is potentially expensive, and it's an uphill battle for the association, and it may involve having to be in federal court. But it does happen that the association successfully challenges. It is an area that has seen significant abuse in the past decade, and unfortunately, the laws are written in such a way that allows for it. There has been some pullback by the state to create some criminal sanctions for those who fraudulently do this. But since that's happened, I don't recall seeing any reported indication of anybody actually being prosecuted for that. But it is a possibility.
Thank you.
All right, thanks for listening.
We're going to take our last break. If you have a question for Robert K., phone number here is 561-623-9429. And if they want to reach your office, Robert?
800-974-0680, or write to us at info@kbrlegal.com.
And we will be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And our expert guest is, this is the first Thursday of the month. So that means K. Bender Rembaum. And then we also, the last Thursday of the month, also have K. Bender Rembaum. So, they give their time. And before, we've only got about 5 minutes, 6 minutes. But let's go to our phones. Let's go to Annie in Boca Raton. Good evening, Annie.
Hey, good evening. Great to hear you both on the radio again with great information.
Thank you.
Robert, I've got a 2-part section for you, if you don't mind, please.
Sure.
I'm actually going to be doing a document review request shortly. We're a HOA, and I did certified mail return receipt. The property manager emailed me back, and I said, I was requesting all invoices, including legal invoices, and he's saying you've requested to review invoices which contain attorney-client privilege communication and work product that is not a record that is required to be provided. Now, I only requested legal invoices, right? I didn't say anything else. And I sent back, I said, you can redact them, but he sent back, the association's legal counsel will have to redact the privileged information at our hourly rate of $300. And will you willing to incur that cost? We passed on to you. And then the second thing, he says, with respect to requests for invoices, they are filed with checks which have personal account information which must be redacted, and they will not be made available for the document review request. Now again, all the invoices, I was under the impression they're supposed to make them available. How they file them, I would assume is their business, but they should make, I'm assuming they should make them available. But anyway, these are the, I believe, excuses he's kind of making for refusing to make them available. And the other is separate. In relation to amendments to the documents in a HOA, I just want to know for sure. We have 61 units. It normally requires 2/3 majority to vote on it. But of that 2/3 majority, how many people would have to vote in favor of the amendment for it to pass? Or how does that work exactly? I know
well, we can address your amendment question first.
Okay.
If your documents require 2/3 of all voting interests, assuming no one's suspended for delinquency or violation that's properly done under the statute, then you just take the total and you see what 2/3 of that is. If it's 2/3 of those who are participating at a meeting in which a quorum has been established, then the maximum quorum would be 30%. And then it'd be 2/3 of that number, unless your documents have a lower quorum number, and then you go 2/3 of that. So I'm assuming you have the 2/3 of everybody.
Yeah, I think it's 2/3 of everybody.
Yeah, amending the document shouldn't be that easy. So, however many units there are within the HOA, then that would tell you your main number, and then 2/3 of that. On the issue of
is it 2/3 of the people who would have to vote in favor, or is it just 2/3, the higher percentage of 2/3 of the people? For example, if 42 people voted, 42 people were there, and 23 voted in favor and 21 voted no, would that qualify?
It depends on the specific language of the declaration as it relates to amendments. So if you have that there, you can tell me what it says, and I can tell you. If you don't, then you have to look at that, because it may say, if it says 2/3 of those who vote, it's usually tied to where there's a quorum. So chances are it's going to be 2/3 of everyone, which means you'll need 2/3 yes votes.
Okay.
Now, on your document request, it's not your obligation to pay for the redacting, it's their obligation. And they have to make those available to you, or they would be in violation of the statute. Now, the downside for you is that there is no division of condominiums for you since you're in an HOA. So your only option of enforcing is to file a lawsuit against them and let the court address it. And you want to have an attorney assist you in doing that if it becomes necessary. Now, you may get an attorney to assist you with the document inspection request to get them on the right page, so you don't have to go through all of that. And that would be far less involved and less costly, but you also wouldn't get prevailing party attorney fee under those circumstances. But whatever redacting has to be done, that's on them, not you. And just because they have to do it to meet your request doesn't mean that they can get out of it.
Right. Excellent.
Thank you so much. Well, we've come to the end of another Ask the Experts. Robert, give everybody the phone number to the office.
You can reach us here at 800-974-0680. Or you can write to us, info@kbrlegal.com. Go to our website, kbrlegal.com. There's a contact box on the first page. Fill out, and someone will get back to you that way.
You're the best. We'll see you again next month. And go back with us again the end of this month, last Thursday of the month. But we will see you all next week with more Ask the Experts. Thanks, Robert. Get better.
Good night, everybody.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.